I think that when it comes to onward transfers, especially in between the institutions and also with third states, it's very important that in Europe there's a very strict purpose limitation, a very strict set of possibilities to process personal data. And sometimes we even have really forbidden links. I mean, in Germany, derived from our historical experience, we had a separation between intelligence and police. This already is overcome over the European level, or although we Germans wouldn't admit that this is overcome already. Because, for example, Europol is connecting this information already. But I think that there is a concern about the question who is deciding at the end if data has to be disclosed to other institutions or to third states. And therefore, I think that Europeans would insist on having also the originator to also have an opportunity to co-decide if data is onwards transferred or not. And in addition, it's very much very important because we have this experience out of our old directive, our old data protection directive in the private sector. When it comes to onward transfers, then we always talk about adequate data protection. And I think in our times, it is very much important to really define what is adequate and to define principles when also doing onward transfers, especially to third states. Because otherwise, I think our systems and principles, also in between the EU, US and the EU, will erode because there are other frameworks, other legal systems working in the world. And I think if we open up these, it would be very problematic.
Do you want to add anything, Greg?
Onward transfers are indeed problematic and need careful attention. And as Jan has said, when we created the privacy directive for the private sector in 95/46, we had this adequacy requirement that you could transfer data from Europe to other countries only if those privacy protections in those countries were deemed to be adequate in our view. It was not to bother our partners, actually. It was to prevent the circumvention of the European rules by simply transferring the data to another country and then you can do what you want. So that was the original intention of this adequacy requirement when it comes to third countries. And it is still a concern to which countries our data go and how they are protected there. And when we have these specific agreements on PNR or on TFTP, I mean, this is always a very difficult point of the negotiations.
Thank you. So,
do you want, Marianne, perhaps I can just also add something which is mentioned by Edward. I mean, the fact of the existence of the Patriot Act is always, or has always been a big challenge to us to accept quite the adequacy. And it challenges me right now because this would be, you know, that this would be impossible in a European constitutional framework. And therefore it's also really a question to all these measures, how they fit in such a framework.
If I can, Barry, just because I'm wrapping up, I think that that's a very fair point and one that we'll try to be more transparent about in terms of the usage. But in terms of, you know, having the originating country know if there's any onward transfer, absolutely, completely agree. I think that's very important. And to make sure, even, so we have to go and make sure that if indeed, which we don't do all that often, but if indeed we do transfer to a third country, we have to go and say, you know, check that. We don't like the word adequacy because the U.S. isn't adequate, but that's okay. And by the way, talk about self-worth, right? I'm not adequate. What does that mean? But but we'd have to make sure that the same standards and so on are applied. So I completely 100% agree with Philipp, Jan Philipp. And on that note, there is no clash of civilization, so I have to go.
So if we just going to ask Edward to comment in a moment, but while we're doing that, if you have a question, please come up to the microphone. And we'll take questions for about 20 minutes. Edward?
Yeah. On your point as to the onward transfers, in the U.S., transparency, if any, with respect to onward transfers of government data is provided by the provisions of the Privacy Act for what's called an accounting of disclosures. However, DHS and most other U.S. agencies have exempted virtually all law enforcement databases from the accounting of disclosures provisions of the Privacy Act. I won't ask Mary Ellen to comment on pending litigation, but it's a matter of public record that in my current Privacy Act lawsuit against the DHS related to their refusal to provide either much of my airline reservation data that they have or an accounting of disclosures, their position is that even for U.S. citizens, the whole system of records has been completely exempted from any access or accounting of disclosure requirements under the Privacy Act. And that's true for most law enforcement databases.
So, are there questions? Microphones on either side, in either aisle. If not, this is CFP first.
Thank you. Kasia Szanielewicz, Panoptic on Poland, Europe. If there are no questions, I allow myself one not directly related to what you've been talking about, but in the description you mentioned of the panel, you mentioned there will be some discussion on private entities, and this is my point of concern. We've talked a lot about governmental exchanges of data. I wonder if speakers have any views on the chances of making US-based companies obliged to European standards on data protection. I heard from some insiders that FTC is talking with big companies in the US about the change of their policy, but are there chances of that change really happening, and what political factors would you see speeding up that change, if any? Thank you.
Anyone want to take a crack at that?
I would say that you will see changes by U.S. companies when they are forced to. And by that, I do not mean when a law is enacted. I mean, if a compliance officer comes to the board of a U.S. company and says, there's some law that says we're supposed to do something in some other country. Do they do it? No. They say, well, what's it cost us if we don't? They will comply when they see them or their competitors suffering legal sanctions for non-compliance sufficient to impact their bottom line. So it goes back to what I said before. We'll see movement in the private sector. Most U.S. companies have ignored the EU Data Protection Directive and continue to operate in Europe as though it didn't exist. And they'll start changing if and only if and when they start being hit with painful sanctions by EU data protection authorities.
Yeah, I think that at the moment, as we are revising our own data protection framework in Europe, this question arises that there has been a directive which would be applied to situations where US companies are acting in Europe and offering their services to Europeans. There are provisions in this directive, and often it's questioned if all those provisions are fulfilled. And therefore, we as the European Parliament are following the Commissioner, which we just heard, Commissioner Viviane Reding, on the question how to improve this. That companies who are offering services in the European Union, of course, have to comply with European Union data protection rules, and that European citizens also, when taking services, for example, in Europe, can trust that European data protection legislation will be applied then. I think that this is not a question of a fundamental question. This is a question of how to enforce and how to really how to really comply with our own legislation. And I think that at the moment we are debating on several things, also especially on the question of applicable law. And obviously, there are many people in Europe who think that if we don't want to have a race to the bottom in favor of big companies, then we need to have strong provisions on the applicable law when offering services.